I want to welcome you, and I want to welcome everyone else back from the break. Sorry, apparently, like Professor Carter, my teaching voice has been left. It's Friday. And it is my great privilege to introduce the second panel. For the longer versions of the biographies, since I'd rather you heard more of their voice and less of mine, especially if you can't hear mine, I will refer you to the program. So let me say just a little bit briefly about our main speaker and the two commenters. Lisa Kloppenberg, Dean and Professor of Law at the University of Dayton School of Law, is someone about whom it can be said without exaggeration that she has written the book on constitutional avoidance. She has, in fact, written the book on constitutional avoidance, Playing It Safe, How the Supreme Court Dodges Hard Issues and Stunts the Development of Law. I paused in a funny way, but you understand. Published by the NYU Press. She is a graduate of the University of Southern California Law Center. She clerked for Judge Dorothy Nelson on the Ninth Circuit, has taught at the University of Oregon, has written not only the book on constitutional avoidance, but a number of articles on the subject, as well as writing extensively on alternative dispute resolution, taught at, I think I mentioned, the University of Oregon, and is now dean at the University of Dayton. Melvin Derschlag is my colleague here at Case, a graduate of Northwestern School of Law, former legal services lawyer here in Cleveland, has written extensively in constitutional law and federal courts, largely focusing, but not exclusively by any means, on federalism issues. Michelle Slack is a proud product of this law school. Apparently not the only one in the room. Graduated in 1994, after which she clerked for the Honorable Frank J. Battisti in the Northern District of Ohio, and upon his death, the Honorable Robert B. Krapansky, sitting by designation in the district court. She then was a litigator in the civil division of the United States Department of Justice, and now teaches at Southern Illinois University School of Law. And I probably made that longer than I had promised. I will now get out of the way and let the panelists do the heavy lifting.
Good morning. I'm grateful to the law review editors at Case for organizing this conference on judicial independence and extending me an invitation to participate with such esteemed scholars. I begin with the presumption that courts are not alone in wielding the responsibility and power of constitutional interpretation. Congress and state legislatures, federal and state executive officers, and many others act to interpret the Constitution on a daily basis. For example, police officers, public university officials, and local politicians. Our divided system of democratic governance affords an opportunity for dialogue among government officials and the electorate in a variety of forms as constitutional law evolves over time. I believe it is critical for this to be an ongoing, long-term dialogue in which judges, legislators, and other constitutional actors participate vigorously in shaping our understanding of the Constitution's protections and limitations. We hear a lot of rhetoric about judicial activism in campaigns. We see evidence of threats to judicial independence from some quarters, including the targeting of a particular judge for an unpopular decision with death threats, email or media campaigns, calls for recall, or impeachment proceedings. You might, for example, remember the furor generated by the decisions of Judge Baer in New York and my friend Alfred Goodwin on the Ninth Circuit for the Pledge of Allegiance ruling. Judicial independence can be threatened systemically as well through failure to provide sufficient funding for judicial operations, highly politicized federal judicial confirmation processes, and the increasing cost of judicial campaigns in many states. As both Democrats and Republicans work overtly to elect judges or gain confirmation for judges who share their views, charging judges with those who do not share their views with judicial activism, as Professor Jay said, is truly the game the whole family can play. It applies now to liberal and conservative judges. Bar associations, of course, and judicial organizations frequently voice concerns about the need to protect judges from encroachment on judicial independence. One way in which judges themselves may try to deflect political pressure from courts and thus promote judicial independence is by resorting to avoidance techniques. The avoidance doctrine urges judges to avoid decision of unnecessary constitutional questions. It encompasses a number of tools, from justiciability barriers and abstention doctrines that bar courts from ruling on the merits of issues, to minimalist approaches to decision-making if the merits of an issue are reached. Sometimes constitutional rulings are merely delayed because of avoidance. Sometimes they are completely avoided. Many judges and scholars have praised avoidance as a way to preserve judicial independence and promote deference to other constitutional actors. The avoidance doctrine is long-standing, but it's been praised frequently by the Rehnquist Court as a foundational principle of constitutional adjudication for federal courts. Many state courts employ similar presumptions about avoidance. Today, I will briefly reflect on some of the costs of avoidance, which I think are too often overlooked, and I will question some of the rationales proffered for avoiding decisions of controversial constitutional issues. When courts employ avoidance techniques, do they actually act in a less aggressive manner and thereby promote judicial independence? And even if some avoidance techniques foster judicial independence in the short run, do they foster a vibrant, long-term role for the judiciary as an independent interpreter of the Constitution? I will group the justifications for avoidance into a few categories based on Justice Brandeis's famous Ashwander formulation from 1936. Perhaps the most understandable and defensible justification is the proposition that federal courts should avoid unnecessary constitutional questions to promote federalism and separation of powers. Thus, to the extent Congress or a state is charged with authority in a particular substantive area, courts should carefully ensure the ability of these actors to interpret the Constitution in their work by not foreclosing options. Judicial review that invalidates another branch's constitutional work should be a last resort due to its purportedly delicate and final nature. Similarly, states and other constitutional actors should be given the benefit of the doubt where possible, and their actions repudiated only when absolutely necessary. While deference is surely an important and valid stance for courts in our multi-layered democracy, it's not easy to apply. The precise dictates of federalism, for example, and separation of powers are not clear, making the judgment call about whether law saying is necessary more difficult. Likewise, these are changing areas involving difficult constitutional and political issues, as well as fairly vague and broad constitutional principles. In recent decades, these issues have emerged as major areas for power struggles between the federal and state governments, businesses and individuals, and others, with courts delineating the scope of these powers regularly. For example, the Rehnquist Court's judicial activism is most obvious in its many closely divided federalism rulings of the last 15 years. It is evident since the war in Iraq that the President and his advisors share a broad view of separation of powers not shared by all judges or legislators. While avoiding constitutional issues to afford time for some of these political battles to play out or the crises to diminish may be attractive, it entails costs for the parties who must spend excessive time and expense in securing protection for constitutional rights. Additionally, a court's invocation of an avoidance mechanism does not always lead to greater deference to other actors or advance constitutional dialogue. A second set of justifications for avoidance I find even more troubling. These concerns center on the pressure on courts resulting from constitutional decisions. They include a court's credibility and viability and are directly linked to fears for judicial independence. The Ashwander formulation arose, of course, in part as a response to the activism of the conservative U.S. Supreme Court during the Lochner era. The fears of political reprisal and long-term credibility of unelected Article III judges certainly animate the general avoidance doctrine, as captured so well in Alexander Bickle's work on the counter-majoritarian difficulty and the passive virtues. I believe these concerns have often been exaggerated. Many courts have thrived during much of the last century, becoming increasingly important in constitutional adjudication, despite political attacks, funding battles, and other pressures. Courts in the United States, along with courts in other countries, have played a significant role in the development of constitutional law, sometimes even in socially sensitive areas, without much success by those who attempt to thwart them by jurisdiction stripping laws, budget restrictions, or through other means. Courts have made numerous decisions regarding federalism, separation of powers, criminal procedure, privacy rights, race and gender relations, sexual orientation, and religion over the past century, without diminishing significantly in power or, I believe, in the public's perception of credibility. Maybe the public has always understood the connection between law and politics. Thus, having courts seen as active participants in constitutional dialogue with more robust judicial review and input on the most socially sensitive controversies of the day does not clearly result in a less independent court system. Even if the fears regarding continued independence for the judiciary are more credible than I perceive and actually might force changes on courts, judges play an important constitutional role in checking the majoritarian impulses of other branches or governments or politicians who are under greater pressure than judges, even in our highly partisan courts, to respond to the crisis du jour and majoritarian sentiments. Litigants must sometimes bring issues to courts precisely because a legislative body or executive officials have ducked a controversy for fear of retaliation at the polls. This role is particularly apt for those judges with Article III protection, which does not include a good portion of the federal judiciary today, given the growth of magistrate judges. State judges, however, also are often called upon to decide controversial issues because other political actors do not want to take the heat, or because someone challenges state or local decision-making, including challenges to direct democracy measures, which occur in over half our states, that are not crafted carefully, or measures implemented without sufficient regard for constitutional concerns. Although state judges do not have as much protection as federal judges, they of course also swear to uphold the law, and we expect them to act impartially in interpreting applicable law. One of the most important functions of a judge, in my analysis, is to ensure that an individual or an entity's constitutional rights are protected from governmental overreaching. Finally, avoidance techniques are justified by courts sometimes because of the paramount importance of constitutional adjudication in our system. This might be a fear of foreclosing other constitutional actors or a fear of issuing an unpopular decision that might impact the court's credibility. Prominent judges and scholars have addressed these concerns in discussing the federal court's role in abortion cases and desegregation cases. The rights protection function of the court, as well as the paramount importance of constitutional adjudication, should actually lead to less avoidance of constitutional issues rather than more. Moreover, some of the Ashwander justifications contain faulty assumptions about the delicacy and finality of judicial review. Fears that court rulings will foreclose future legislative action are often excessive, although it is admittedly very hard to gauge the impact of constitutional rulings and account thoroughly for all the pressure points which causes constitutional law to change, even after the U.S. Supreme Court has issued an authoritative decision in the area. Judicial review should be viewed again through a long-term lens in which it's a process of responsive dialogue involving many constitutional actors and future jurists so that constitutional understandings are able to change and develop over time. One of the primary aims of my book on avoidance is to demonstrate that due to the concerns about deference, foreclosure, and threats to judicial independence, the U.S. Supreme Court has employed avoidance techniques selectively over the last 3 decades and often used them in categories of cases involving controversial issues or what's been termed by the court sensitive areas of social policy. For example, the court has used avoidance techniques frequently in litigation involving dissident speech, going back to the Cold War cases, civil rights claims and issues of equity for women, racial minorities, gays, lesbians, and cases involving the protection of religious minorities. Sometimes the political pressure is overt. The justice is actually right about it. More often, the political controversy goes unstated. The decision to avoid a constitutional issue is itself a decision, and it is impossible to separate our analysis of the procedural tools completely from our view of the merits of the underlying constitutional issues. As judges determine whether it is necessary to address a constitutional issue, their views of the merits are intertwined with the decision-making. Political pressure on courts may influence when courts issue minimalist rulings, affording less clarity and guidance to other constitutional actors. For example, in the Ten Commandments pair of cases from the 2005 term, Justice Breyer found 2 fact situations distinguishable, and the court upheld one court display of the commandments, but not another. Some commentators might think that the justice was splitting hairs. Judge Posner praised this minimalist technique precisely because, quote, compromise is the essence of democratic politics, and hence a sensible approach to dealing with indeterminate legal questions charged with political passion. This is Bekelian prudence minus Bekelian teleology. To give complete victory to the secular side of the debate, he says, or for that matter the religious side, could be thought at once arrogant, disrespectful, and needlessly inflammatory. Again, we come to a question of necessity. When is it necessary for the U.S. Supreme Court to decide a social controversy like the use of the Ten Commandments with constitutional implications clearly at its heart? In my analysis, the costs of avoiding constitutional questions are borne too often by the poor and marginalized in our society, those most in need for help securing constitutional protections for their rights and civil liberties. In contrast, in the federalism rulings of recent decades, the Supreme Court has not been hesitant to address other controversial constitutional issues, holding against victims of domestic violence, state workers who claim discrimination, and those claiming intellectual property rights against state universities. While the Rehnquist Court has not created a vibrant body of equal protection law for those on the margins of our society and still subject to serious discrimination, it did use the Equal Protection Clause, as other commentators have said, when it intervened in the Bush v. Gore dispute, despite a constitutional role set forth for Congress in the elections area. Nevertheless, Congress and the public apparently acquiesced, says one commentator, without hurting the court's credibility significantly, at least according to some national polling. I don't pretend to have done a thorough empirical study of the court's constitutional jurisprudence and located every choice to invoke avoidance. As you can imagine, it comes up in thousands of cases. I've found some interesting patterns, however. Perhaps my concern about the Lochner specter of threats to judicial independence, precluding courts from addressing socially controversial and important area of laws, influences my perception of the patterns. My life experiences as a woman may also influence my perceptions, and my faith's concern for the poor and marginalized surely shapes my analysis. One of my hopes is that more scholars will be intrigued by this inquiry and share their perspectives on the patterns of when courts deploy avoidance tools and the effect of that deployment on constitutional dialogue. As an example today, I will focus on one aspect of avoidance, the use of the canon of statutory construction to avoid unnecessary constitutional questions. The avoidance canon is a tool used to interpret statutes narrowly if they raise serious constitutional doubts. The avoidance canon is premised in part on deference, and rather than invalidate troubling legislation, a court merely revises the offending legislation and returns it to the legislative body. In theory, this device affords legislatures another opportunity to consider the constitutional issues posed and perhaps strike a different balance, more close to the court's perception of the constitutional balance. In practice, the canon is sometimes deployed with considerable aggressiveness. My work and that of many other scholars provides numerous examples of the contortions in statutory construction that can result from using this purportedly deferential canon. Some courts have used it to create shadow or phantom constitutional norms rather than enforce clear limits defined by existing precedent at the time of the legislative enactment. Of course, a court's view of the scope of constitutional protection will sometimes differ from the legislature, and where there is room for debate, as there often is, the court can use the canon to enforce its view of the constitutional concerns, developing constitutional law at a sub- or quasi-constitutional level, without clear demarcation of constitutional boundaries for other constitutional actors. The Supreme Court has sometimes used it to develop these phantom norms, and then in later cases chided the governmental actors for not avoiding a constitutional danger zone so clearly marked by its earlier precedent, when that was all at a sub-constitutional level. It's hard to see how that's significantly different from direct constitutional law saying in the first instance, at least in terms of deference and the linked potential to promote judicial independence. In some circumstances, courts have used the canon to rewrite statutes almost completely, clearly conflicting with legislative intent. Courts essentially remanded a controversial law so the legislature may not have the time, or when the legislature may not have the time or political will to revisit the issue. An interesting literature examines the competence and proclivity of Congress to respond to such responses. It often appears difficult for Congress to counter those phantom norms. Thus, while the canons advanced as a rich mechanism for dialogue between courts and legislatures, it is frequently used as a way of deciding issues on the merits without a full airing, without more reasoned elaboration, and without purporting to rule on the merits at all. In 1988, the court applied the canon to uphold a congressional act aimed at protecting children from exploitation in pornographic materials. The court found a scienter requirement in the act. The defendant must have known that he was using a child under a specific age in the pornographic material. The court narrowed the reach of the act to avoid constitutional problems it perceived without a scienter requirement. Justices Thomas and Scalia dissented, finding those constitutional doubts baseless, and they accused the majority of rewriting the statute and eviscerating congressional intent, because existing precedent did not clearly demark this danger zone at the time the law was enacted. The dissenters argued it would be better to invalidate the act entirely, affording Congress more leeway to rewrite the law. The majority might have avoided some political heat, clearly, by upholding a law aimed at protecting children from exploitation. But it did make a decision about the content of constitutional law, at least at a subconstitutional level. And that interpretation will have a real-world impact on prosecution of purveyors of pornography. This reading of the Constitution seemed to conflict with congressional intent, given the text, history, and context for the enactment, and thus the use of it was not deferential. Did avoiding the constitutional question promote judicial independence in that circumstance? If so, it seems to do so by elevating form over substance, perhaps designed to avoid media and public scrutiny. If you agree with the court that the law was too broad without a scienter requirement, you might prefer that a court memorialize that with a definitive constitutional ruling. If you disagree with the court that a scienter requirement should apply, at least when children under 16 are used in pornographic depictions, the court's quasi-constitutional ruling precludes the protection against child pornography, at least unless Congress rewrites the Act, effectively foreclosing Congress in much the same way a constitutional ruling would. How troubling is the use of the canon in contrast to other avoidance techniques? When the U.S. Supreme Court avoids constitutional questions through the use of justiciability or abstention doctrines, as it did recently in the Pledge of Allegiance case, it refuses to deal with the merits of the issues implicated, at least for the moment. With justiciability, that means, as Professor Bagenstos has pointed out, that many types of harms are not cognizable in federal courts today. In contrast, use of the canon can provide some guidance on the justice's leanings on a given constitutional issue. If a lower federal court or state court engages in avoidance, the ruling has less precedential force, of course. Perhaps this leaves more room for dialogue on issues that judges perceive raise serious constitutional questions, and an analog to the idea that states might sometimes function as laboratories for democracy. Judge Posner has characterized Bickel's avoidance project as promoting a coercive kind of dialogue. He says it would be a Bickelian court's hope that the legislators would have their eyes opened by the court's tutorial, or that reenactment would founder on the inertial difficulty of enacting legislation. Professor Murchison has said that the canon advances a rather muffled and tentative dialogue with a blend of indirection, impatience, pause, and reply, but he nevertheless concludes it's an important and useful device. I don't believe courts will completely reject avoidance techniques, and I agree that judges need some flexibility in adjudication. I've instead suggested some limits for courts to consider when they have the option of invoking the canon. Essentially, I would reverse the Rehnquist court's presumption. The court suggests that federal courts should pause at the outset of a ruling and ask, is deciding this constitutional question truly necessary? I suggest that courts consider instead the costs of avoidance to the litigants and others before avoiding decision, and also ask whether the rationales for avoidance are promoted if the canon is used. Would deference and judicial independence truly be advanced if the canon is deployed in a particular case? It seems to me that direct repudiation by a court, if it perceives clear constitutional problems with legislation or executive practices, is a better way to protect and interpret the Constitution. I believe this doesn't need to foreclose all dialogue. The level of foreclosure, of course, depends on the level of court. The impact of one trial judge's ruling in Ohio differs from the impact of a Supreme Court ruling striking down a congressional act, at least in terms of finality. I've argued that it's most important for state and federal appellate courts not to avoid controversial and important constitutional issues automatically. If the U.S. Supreme Court does avoid a federal enactment, I believe there is also room for dialogue. The President can use his bully pulpit to foster public opinion, can nominate Supreme Court judges, justices, and other federal judges sensitive to the executive or congressional view of the balance of security and liberty in an age of terrorism or whatever the issue is. Congress can hold hearings, produce other legislation. Members of Congress can offer speeches to bring public attention to the matter. As we've seen, states are already responding to the Kelo ruling on eminent domain. In my estimation, there seems to be a great gulf between the justifications for avoidance, the described deference, credibility enhancement, etc., and the actual effects of avoidance and judicial review. Moreover, it's not clear that a purportedly less active court choosing to use the avoidance canon to rule at a subconstitutional level rather than engage in direct law saying significantly enhances or preserves judicial independence. Justice Breyer, very mindful of the primacy of legislative decision-making, discussed recently the need for an independent judiciary. He asserted that emerging democratic societies see a need for an independent judiciary to help secure basic liberties. In concluding, I'd like to quote him. That independent judiciary may protect liberties by helping gradually to develop among citizens and legislators liberty-protecting habits based in part upon their expectation that liberty-infringing laws will not turn out to be laws. And such protection might seem particularly necessary in a new democracy, or one with a highly diverse citizenry or sizable minority groups. That independent judiciary may also protect through the kind of force that a court can bring to bear when, faced with a law that clearly violates a constitutional provision, that court says no. In many ways, his advice is sound for preserving judicial independence in our democracy as well. Thank you very much.
I don't know why this is here. First, let me extend two thanks. One, obviously, to, and this is very personal, not institutional, to Sarah Bush and the Law Review staff for putting this thing together. And the other is to Lisa Kloppenberg, who, and for her extraordinary work in this area. And the two combined has actually forced me to think about a subject that I have conscientiously avoided for a very long time, because quite frankly I can't make heads or tails of it. But I'll try, or at least I'll start. And for the next statement, I apologize to any of the students in the audience, or former students actually, because what I'm going to say is that the starting place, as it inevitably must be, is Marbury against Madison. And in particular, the statement in Marbury that it's emphatically the province and duty of the Judicial Department to say what the law is. And why is this a starting place? Because the central question in constitutional law is the so-called who decides question, or to state it in a way that's more pertinent to this panel, who decides what questions, when, and how. Lisa Kloppenberg, in her paper today, I can't figure this out either, in her paper today and in previous writings, apparently takes Chief Justice Marshall at his word, particularly the duty part of his famous statement. If I read her correctly, her central position is captured in the following quote: "The rights protection function of the courts, particularly federal courts in our democratic system, as well as the paramount importance of constitutional adjudication, should lead to less avoidance of constitutional issues by the courts, not more." And as she said near the end of her talk, at least there ought to be a presumption against avoidance rather than the other way around. Now, on a number of points, I agree with Lisa Kloppenberg, but I'll only mention 3 points. First, she is certainly correct that is often troublesome when courts abandon or defer the protection of individual liberties to the popularly elected branches of government. Second, I agree that some of the often cited benefits of avoidance have proven to be illusory. I don't have time to go into all of that today, but certainly the narrow construction of the syndicalism statutes during the early and mid-1950s is a good example. In the same vein, if promoting a court-Congress constitutional dialogue is one of the purported benefits of avoidance, I doubt very seriously that we will get that from the Schiavo guardianship matter or from Justice Breyer's valiant effort to save the mandatory sentencing statute in the United States against Booker. Finally, Lisa is correct to criticize the manipulation of standing, mootness, and justiciability doctrines to avoid, quote, substantive, unquote, whatever that means, constitutional rulings. Among other things, a device, in part at least, designed to express judicial humility and fallibility, ends up being the ultimate tool of judicial discretion. And although I hate the term and I'm loath to use it, judicial activism. Now to my points of disagreement. And I will mention three. I'll evenly balance it. First, judicial avoidance is an inevitable byproduct of a system that separates the judiciary from the political branches. There is simply nothing we can do about it. Second, there are occasions when avoidance can stave off an erosion of individual liberties where structural issues restrain the court's ability to recognize or to expand individual rights. Finally, avoidance can contribute to reducing constitutional confusion in those cases where constitutional consensus is out of reach. And I want to briefly elaborate on each of these 3 points. Point 1. As we all know, or if you don't, I'll remind you, avoidance did not begin with Justice Brandeis's concurring opinion in Ashwander against the TVA. It had origins far earlier than that, and the reason is simple. It's the so-called majoritarian difficulty. The court, even in its more hegemonic moments, understood that its decisions had to account for the powers and prerogatives of the other branches of government. And that is precisely what avoidance at its most fundamental dimension purports to do. Lisa apparently does not disagree. And here I quote again, "The court predicates its avoidance doctrine on separation of powers principle, federalism concerns, and the final and delicate nature of judicial review," unquote. These are constitutional, not prudential concerns. They recognize the limits of judicial power, not the limits of judicial discretion. Well, if much, although concededly not all, of avoidance is founded upon constitutional rather than prudential concerns, avoidance is inevitable in a system in which an unelected judiciary has an independent and prominent, if not exclusive, lawmaking role. And this is true even if it's correct that we make too much of the downsides of constitutional confrontation between the court and Congress, and indeed even if Congress might yearn for some clarity as to its constitutional authority, although quite frankly I wonder about that latter proposition. Maybe the best we can hope for is that avoidance be used more selectively and when used, not abused. Number 2, no branch of government functions without recognition of the others. Congress rarely enacts legislation that it knows will be vetoed by the executive, certainly if an override is not likely. And the executive rarely proposes legislation that will be, as they used to say, dead on arrival, except maybe as a negotiating technique. Rather, Congress will ordinarily tailor its legislation to avoid executive objections, and the executive will draft legislation to satisfy or at least mollify anticipated congressional complaints. Court tends to play by the same rules. When it decides cases, the court is well aware that the significance of its decision extends far beyond the named parties. And here I am referring to the court's interpretation of individual rights to account for constitutional federalism and separation of powers. It is well established that individual rights have on occasion been given a narrow interpretation to account for federalism values. Most recently in Johnson against California, Justice Thomas, joined by Justice Scalia, refused to recognize as race discrimination the California Department of Corrections' unwritten policy temporarily separating newly arrived prisoners for a 60-day period on the basis of race. Rather, what they said was this was a case of state prison administration, which required the court to defer to the discretion of state correction officials. Even Justice O'Connor's majority opinion did not hold that the California policy was unconstitutional race discrimination. Instead, the case was remanded to the district court to afford the state the opportunity to demonstrate that it had a compelling interest and that the racial separation policy there was no less drastic means of fulfilling that state policy. Separation of powers have had the same impact on the scope of individual liberties. The First Amendment is replete with cases in which respect for the prerogatives of the political branches have trumped free speech assertions. To further illustrate my point, I want to mention two additional cases, one involving separation of powers and the other federalism. Separation of powers, and perhaps the crowning example is Korematsu, in which the court, despite its incantations of how abhorrent racial classifications were, essentially deferred to the judgment of the Japanese-hating military governor of the Western Defense Command that security concerns warranted removal of all Japanese, aliens and citizens alike, from their homes to inland, quote, detention centers, unquote. Now, Korematsu was decided 61 years ago, 10 years before Brown. We've come a long way since then. It's consequently tempting to say that such a result would never occur again today. But that's all but clear. The late Chief Justice Rehnquist wrote that he was not confident that the same result would not obtain if similar circumstances arose today. And given the dissenting opinion in Johnson and Justice Thomas's dissent in Hamdi, it's likely that Chief Justice Rehnquist has two more adherents. Was there an alternative? Justice Jackson thought so. In a dissenting opinion that was avoidance writ large, Jackson argued for no decision at all. Why? Because, and I quote, the existence of a military power resting on force so vagrant, so centralized, so necessarily heedless of the individual is an inherent threat to liberty. But I would not lead people to rely on this court for a review that is wholly delusive. I assume he was referring to Justice Black's majority opinion. Put in a more modern setting, is there any doubt that the process due Mr. Hamdi and his fellow prisoners, if and when the court ever decides that matter, will account for the President's extensive and largely indefinable war powers, just as the process due a prisoner who is transferred to a supermax facility accounts for the fact that federal courts are not equipped to micromanage state and federal prisons. Second case, the federalism example, is one used by Lisa in her book. The avoidance technique was to deny standing, and the case was the much maligned city of Los Angeles against Lyon. In Lyons, the court held that the plaintiff lacked standing to obtain an injunction against the use of chokeholds by the Los Angeles Police Department because he could not demonstrate that he, the plaintiff, was in danger of being subject to chokeholds in the future. injunctions operate prospectively. The standing ruling avoided the question of whether the policy of using chokeholds when an officer's life was not threatened constituted a substantive due process violation, as the District and the Ninth Circuit courts had held. The impact of Lyons on access to the federal courts was unmistakable. And in terms of where my sympathies lie, I would have liked the Supreme Court to have affirmed the lower courts on the merits. But, as Justice Black described it, our federalism stood in the way. It would have been very difficult for the court to monitor the use of deadly force by police departments without subjecting everyday police activities in every police department in the nation to federal contempt proceedings. That would change the relationship between the federal courts and the states. Was there any choice but to either limit standing or to limit the right? I don't think so. Which would be the better outcome? I have absolutely no idea whatsoever. The bottom line, I guess, is that it is not necessarily true that the life tenure protected federal judiciary is more able to protect individual liberties than the political branches of the federal government or the largely elected state court systems. The constraints are different. They're political in the latter and structural in the former, but history has demonstrated that structural norms can be as corrosive of individual liberties as political responsibility, and that, of course, is assuming that the federal judiciary is agnostic to political considerations, a subject of a different nature. 3, is it more likely that clarity will be enhanced if constitutional issues are confronted and debated directly on the merits? Not necessarily. Indeed, reading some recent court opinions, one might yearn for a little avoidance here and there. Just 2 weeks ago, the court decided Gonzalez against Oregon. That was the physician-assisted suicide case. As many people predicted, the court avoided the difficult constitutional issues by holding that the Controlled Substances Act did not authorize the Attorney General to determine what is a, quote, medically appropriate use of a drug. As Justice Scalia and Thomas, joined by the new Chief Justice Roberts, argued, the majority's interpretation of the statute was anything but preordained. But it disposed of the case. Now let's imagine for a minute what the opinion, or I probably should say opinions, would have looked like if the court had tackled the difficult constitutional issues under the Commerce Clause, the Due Process Clause, and conceivably even the Equal Protection Clause. Consensus would be difficult to come by on all 3 plausible constitutional objections. Now, if I ask my law clerk or my legislative intern, as the case may be, to tell me whether Congress could legislate in the area after Gonzalez, would she be in any better position to advise me with an opinion that read, Justice X announced the judgment of the court and delivered an opinion in which Justices Y and Z concur in parts 1 and 2A and C, and in which Justice D concurs in part 3E, et cetera, et cetera, et cetera, then she would be with an avoidance opinion which commanded a 6-justice majority. I may be missing something here, but I don't see how. The point is that extrajudicial constitutional debate that law and political science professors so yearn for may be a little more than a collective dream. Congress may get upset at the court's ignoring expressed intent, as it did in Schiavo and Booker, but it does not necessarily follow that it will be any happier with the constitutional guidance it is getting from the court in the very cases when guidance is most needed and, unfortunately, where consensus is most difficult. Let me just conclude in less than a minute. It may not sound, I'm fairly ambivalent about avoidance techniques. I think they're clearly useful sometimes, not so useful at other times. But I do mention Lyons to suggest that maybe that was one case where avoidance may have actually been useful. And I'm not a purist, and so I am much less troubled by the Court's even questionable interpretation of federal statutes to avoid constitutional questions. If Congress gets upset that its intent is being ignored or being abused, at least Congress has an outlet for its anger. And while it is true that avoidance often preserves the status quo, and the status quo often falls most heavily on minorities and those whose views lay outside the political mainstream, are those interests and individuals better off with an adverse constitutional decision, one that is dictated more by structural than individual concerns, simply because a constitutional conversation may have been prompted? Maybe, but maybe not.
Good morning. I, too, would like to begin my comments by thanking the Law Review, the school, and everyone involved in this symposium. In particular, I'd like to thank Bob Strassfeld, my torts professor, for making my presence here possible today and his efforts in that regard. I'd also like to echo some comments of Professor Marshall about it being good to be home. In fact, I was telling Dean Kloppenberg during the break how it was strangely familiar to be taking notes on things that Professor Marshall was saying here today. This panel is here to answer the question, does avoiding constitutional issues promote judicial independence? And in Dean Kloppenberg's book, Playing It Safe, and in her comments today, the dean has taken the position that there are a number of types of avoidance that the court uses, anything from standing to abstention to the canon of avoidance, and that these tools of avoidance are all too often selectively used in cases that are socially and politically sensitive, the ones that affect those least politically powerful in our society today and most dependent upon the courts to address those issues. I agree with that sentiment. In fact, I'll even point out another area of the law, the one that actually created my interest in the avoidance doctrine, that of immigration cases and terrorism-related cases in which I dealt with as an attorney in the Civil Division of the Department of Justice. I also have firsthand experience having been the law clerk for one of the law clerks for Judge Battisti here in the federal court in Cleveland, the judge who ordered the desegregation of the Cleveland public schools. So I'm aware of the pressures that are put on judges, both by the public and by the other constitutional actors, when they render politically unpopular decisions such as desegregation orders. I'd also like to agree with Dean Kloppenberg's comment about the respect that one must show to other constitutional actors as they interpret and do other things that those actors do with regard to the Constitution. After all, they also take an oath to uphold the Constitution in their role. And that I also want to agree that we should give them the benefit of the doubt when an issue can go either way. In fact, that's a focus of my remarks today. Since I'm the only thing that keeps us now from lunch, I will jump ahead. In my comments and go to what I really want to talk about today. I, too, want to focus on the canon of judicial avoidance and its use and misuse, perhaps, as well as some presumptions. But I'm taking a different angle at approaching this issue. I want to focus on the canon because unlike other types of avoidance tools like standing or abstention, what ends up happening is you do create these quasi-constitutional rights, what Judge Posner has referred to as the penumbra, What you have maybe is at the center core something that's clearly unconstitutional in an interpretation, and then you end up with this gray zone outside that center, and where we have the serious constitutional issue, but the court's not going to tell us if it's unconstitutional or not. They're simply going to say that this is a serious constitutional question. And in fact, this is part of Justice Scalia's criticism of some of the times in which the court has actually invoked the avoidance canon. Now, one of the Ashwander principles is the idea that avoidance creates a chance for there to be a dialogue among the co-equal constitutional actors. But I wonder how that could be, because I also agree with Dean Kloppenberg's remarks that say that courts actually often criticize those actors when they disagree about the constitutional reading that the court has proposed by using the avoidance, and actually will criticize them for going ahead and saying, well, okay, we've considered your decision, and we think we can proceed in that light. They've been criticized for going into the danger zone, as it's put. And my concern is what this ends up doing is creating what I'd like to call a presumption of unconstitutionality. For those gray zone cases where the court's not going to tell us whether it's unconstitutional, the reading, but they're just going to tell us a serious question, it creates this presumption of unconstitutionality. In fact, this presumption can often even be applied when there are much less serious constitutional questions posed in the case. I will use two immigration cases as examples of this point. The first is a case called Zavidas versus Davis, and the other is Clark versus Martinez. Both cases were looking at the question of whether or not it was constitutional to have indefinite detention of aliens. Zavidas was looking at aliens who had actually been here as lawful permanent residents prior to being ordered deported. They did something while in the United States lawfully to make themselves deportable, and then were in indefinite detention, and their countries would not take them back. In Clark versus Martinez, the court looked at the question with regard to people that were never lawfully here. Primarily the Mariel Cuban boat lift people who came to the United States and were rejected essentially at the border and were excluded from admission. In Zavidas, the court recognized that there is a serious constitutional question with regard to these lawful permanent residents who have much greater stake in remaining in the United States, have greater procedural due process rights than inadmissible aliens, and chose to invoke the canon to create a reading of the statute involved such that there was a time limit in which the agency could remove the person or release them into the United States. But they left open the question of what would happen with inadmissible aliens until they confronted the case in Clark versus Martinez. And there, Justice Scalia reminds the court and the dissenters that it's a doctrine of statutory interpretation, not one of constitutional law. And as a result, even though he was in the dissent in Zavidas and criticized the use of the canon in Zavidas, he writes for the majority in Clark versus Martinez saying, but we've got to give the statute the same reading, even though we all recognize that there's much less serious constitutional questions involved in the inadmissible alien cases. Now, the problem that I have when it comes to a question of judicial independence, the problem I have with this is this seems to occupy and negate the presumption of constitutionality. If the presumption of constitutionality is to have any place in statutory interpretation, it has to be for those cases where we're in the gray zone. We might go either way. We're not in the center, where we've decided that it's clearly unconstitutional to have a particular reading. We're in that gray zone. And the presumption of constitutionality is one of those canons that springs from the whole notion that The separation of powers principles and co-equal constitutional actors deserve respect, and they also think about the Constitution when going about their business. In fact, I also have some experience personally with this presumption in respect to, I worked as in part of the working group, the Office of Policy Development and Department of Justice. They screen nominees of the president. And we also help them go through the confirmation process in that regard. I never, ever had a situation in which a judge, a proposed judge to the federal bench, was not asked the question of where would they begin an analysis of interpreting a statute of first impression, and they didn't start with, I would of course first start with the presumption that that statute is constitutional. I believe that this flies in the face of the avoidance doctrine as it's currently used with regard to, well, we're going to invoke it, sometimes we're going to invoke it when a serious question is posed, because it occupies that same zone of quasi-constitutional rights. And this concern is even increased when you see that it's often invoked not where there's two equal readings, not when you say, well, the more constitutional reading, the less troubling reading is the more likely reading. It's all too often invoked when even the court is acknowledging it seems that the most likely reading of this statute is the one that we have the constitutional problems with. In fact, in Zavidas, Justice Kennedy states, this is a statutory amendment of its own that the court is invoking, in obvious disregard for congressional intent. In fact, Justice Breyer, in his majority opinion, even acknowledges this to some respect by saying that we are reading significant limits into other immigration statutes in order to avoid the constitutional issue. This is possibly why some of these decisions have incurred action in the wrath of Congress, and why sometimes the court is faced with threats of their judicial independence. For example, in a case where they invoke the avoidance doctrine, another immigration case called St. Cyr versus INS, having to do with habeas corpus jurisdiction, the Congress's response was a provision in the Real ID Act that said, well, we meant it when we said there shouldn't be habeas corpus litigation. And also an example of that can be seen in the recent legislation that is banning habeas corpus jurisdiction being used to consider cases of detention of the Gitmo detainees down in Guantanamo. And that most likely is, in some respects, especially because of the timing, a result of the Supreme Court granting cert in the Hamdan case, and a result of invoking the avoidance doctrine in Hamdi. But what if the court is trying to say, when it invokes the doctrine, is that we think this reading is not just in the gray zone, we think it's in the center? I think they should say that. And I think that real deference and real restraint would expect them to do that and to use this doctrine itself as a last resort. And because of some of the concerns that Dean Kloppenberg has raised here about the lower federal courts and the state courts using the avoidance doctrine, I'd also say that maybe it should also be a last resort with regard to the courts and be left for the court of last resort in concern over the whole idea of finality of the doctrine itself. So that brings us back to the question of independence. And I'd like to echo the point made and the question raised by Dean Chodosh when he said, independence from what? And I'd like to add, independence to do what? And I believe that to the extent that the independence of the judiciary is threatened, when they step outside of their traditional role, become legislator rather than judge, I think that it is rightfully questioned. Thank you.
In the 6 minutes we have left, I'll try to take 1 minute. They gave wonderful wonderful examples. I thank you both for some of that, although I question whether some of those examples, like Lyons and Korematsu, actually help me make some points that we should be concerned about how avoidance techniques are used. I do admit, I must admit, that I'm older and wiser than when I wrote the book. It might just be age, it could be my term as a dean. You know, I've learned that it's occasionally helpful to avoid confrontations. Maybe it's having 3 kids, but anyway, I agree. So I agree this topic is really hard to get your arms completely around, but I still believe that these 2 questions deserve more thought. Is avoidance truly promoting independence for the judiciary, and is it necessary to preserve judicial independence? Thank you.
We have a little bit of time for questions. Let me remind you there are 2 students with microphones. Please wait till they get to you. Any questions?
How does Michelle reconcile the views of my friend Frank Battisti and Bob Kupinski?
Excuse me?
Can you repeat?
How do you reconcile the views of Frank Battisti and Bob Kupinski? I try to.
It's a local.
I think she wants to invoke avoidance. Any other questions? Yes, Carolyn? There's a microphone.
The thought that occurred to me is that when you go case by case, it is much easier to say, well, in this case, avoidance is a bad idea because constitutional rights have been deep-sixed. But I keep coming back to the overarching point that Bickle makes, which is just systemically. It may be that in no one case can the court say, if we decide this case, all hell's going to break loose. But that we're able to point to this doctrine which says we are a restrained body, whether we are or we aren't, really. It allows us to sort of point to something and say, here is part of the reason why we ought to be respected as an institution, why we ought to be preserved as independent. And it seems to me it's harder to argue that that doesn't serve some purpose in preserving the independence of the judiciary, even if in any given case you can say, look, nothing's going to happen if you decide this case or that case.
I agree, and that's why I think it's important to look at patterns. Also, your comment reminds me of the comment made earlier today that judges, there's also this illusion which might help protect judicial independence of some form, that once you take the oath, you become a new person, you're transformed.
Lisa, I wasn't quite sure if I heard right, so tell me if I'm wrong. It sounded to me like you were saying that there should be a distinction with respect to this particular issue between rights reinforcement and structural enforcement, right? I mean, it sounded to me like you were in favor of the courts going forward if rights were going to be expanded, but not if structural guarantees were going to be put in place.
Yeah.
So that you were favoring rights over, say, federalism.
And so certainly I would see the development as more power for the states under federalism as a growth of rights. So although I've seen these patterns where there seems to be what we would typically think of as the, footnote. Yeah, footnote 4, the minorities that need protection from the courts, and I give lots of those examples. I agree with you that the structural stuff, they talk about structural and prudential reasoning for this doctrine, but you can't separate that, I think, the process and the substance. So even in federalism and separation of powers, while there are more defensible reasons to think hard about avoidance, I still think it shouldn't be an automatic presumption in favor of avoidance.
I mean, if you look at the Rehnquist court, it is tended to say the opposite, right, which is that the structural issues you go right for. You look at the power of Congress, that's going to give you reason to avoid, whereas you're going to be more deferential to legislature with respect to rights, perhaps. But
right.
So, I mean, it just seems to me there's an internal, not inconsistency, but a lack of explanation in your analysis between those 2 very central parts of constitutional analysis.
Yeah, good point.
It's time for one more question. Actually, there's also one more question.
This session has focused largely on the sort of liability phase of litigation. Is there a right, whether it's individual or structural? But there are also issues that arise once liability or the right has been determined with respect to what the remedy ought to be. And I wonder whether in a minute anybody up there wants to think about this. But Brown is a pretty good example where the court punted on the remedy because of some concerns about avoidance. There's a lot of literature about whether that was a good thing or a bad thing, but I wonder whether if we looked a little more explicitly at rights or at remedies, that we might have a more systematic understanding of when avoidance might be appropriate and when not.
I'll take one short stab at it because I did an article about this about umpteen billion years ago, which I've now forgotten most of. But the answer is I think that that the remedy phase of litigation is an important thing to think of in terms of avoidance, particularly when you begin knocking up against institutional concerns such as federalism and separation of powers, because there are some remedies which are obviously more intrusive on those interests than other remedies, and the court may want to avoid intruding too much in the remedial stage on either one of those. Brown is kind of an interesting case because Brown too, the all deliberate speed aspect of Brown has been both praised and maligned, and largely on avoidance grounds, right? I mean, why didn't the court? I mean, the court eventually, with Cooper against Aaron, kind of made some statements, but some people have actually praised the remedy in Brown on avoidance grounds because this was really a groundbreaking case. Had the court not used the all deliberate speed, but had just, kind of used a Cooper against Aaron approach and said, damn it, integrate now or we're going to send in the 82nd Airborne Division, civic unrest would have been precipitated. And so it was appropriate for the court, at least in the minds of some, to have let this issue move far more slowly rather than confronting it directly. Of course, all of these, particularly with respect to remedies and the kind of the issue you raised in Brown, all of this is interesting hindsight. Whether the court in Brown 2 really thought about, and it probably did, but how deeply it thought about the social consequences of an immediate versus a more gradual remedy, and consciously chose the more gradual remedy in light of those social consequences, I don't know. That may have played a part. It also may have played a part in terms of the uncertainty of the remedy itself. The court may have been a little bit unsure about what the remedy ought to be, and consequently tried to postpone it a little bit. I mean, that's the best shot I can give it.
You raise an excellent point, and on Brown, I just point people to Judge Mikva's article, excellent article about when he clerked during the 52-53 term.
I want to invite you all to join me in thanking the panel.
It was great fun.
Michelle, I thought you did well.
Yeah.